Well, welcome again, everyone. It's 2 after, so we'll go ahead and run through some housekeeping items, and then we'll get today's webinar started. I want to thank everyone for joining us on behalf of the National Juvenile Justice Network, the Campaign for Youth Justice and Juvenile Law Center. I'm Allison Clemens, and today's webinar is Keeping Youth Out of the Adult Court, Leveraging Research and Transfer Litigation and Legislative Advocacy. Before we get started, I just wanted to run through a couple things around the webinar service. When you enter the conference, make sure that you've enabled your audio. There should be 2 options for joining the discussion, either telephone or using your computer speakers and microphone. Folks have found that by dialing in via phone, the audio is much better, so we encourage you to do so. And you should be able to change that setting in your control panel. Because there's so many folks on the webinar today, we have everyone muted just to make sure there's no distracting background noise. But later when we get to the question and answer section, we can call on you to unmute you guys so that you can ask questions when called upon. There's also a questions box in the control panel, so if you would like to track questions as the presenters are speaking, you can go ahead and enter those there, and we'll be sure to ask those once we get to the question and answer portion. On your screen in the upper right-hand corner is the control panel that I've been talking about. And if you want to minimize that during the presentation, just click on the orange arrow and the panel will be hidden, and you can click on it to expand it to full size. As I mentioned, if you have a question during the presentation, just type it in the questions box and you can send it to panelists. If we have too many questions today, we'll try to get email answers to you guys after today's presentation. And lastly, we're going to be recording today's webinar, and it'll be available via our website or YouTube channel in the next day or 2. So we'll let you know once it's posted, and we'll make sure to email it to all those who registered for today's webinar with the information and the slides. So with that, I have the great pleasure to introduce today's 2 speakers, Jeree Thomas and Nadia Mozaffar. Jeree Thomas is the Policy Director with the Campaign for Youth Justice in Washington, D.C., and she provides research and policy support to state advocates trying to end the prosecution, sentencing, and incarceration of youth in the adult criminal justice system. Before joining the campaign, she was a Skadden Fellow and a Youth Justice Leadership alum, or I guess she was a fellow and then an alum, and she was also the recipient of NJJN's Youth Justice Emerging Leader Award for all her work on behalf of Virginia's youth. And Nadia Mozaffar is the staff attorney at the Juvenile Law Center. Nadia's work focuses on advancing educational rights and opportunities for children in the juvenile justice and child welfare systems, reducing transfers of youth to the adult criminal justice system, as well as economic justice issues. Before joining the Juvenile Law Center, Nadia was an attorney with the Higher Education Practice Group of Cooley LLP in Washington, D.C., where she advised clients in the higher education industry and assisted with the development of federal higher education policy. So these are 2 of the experts in the field, and with that, I'm going to turn it over to Jeree. And let's just make sure, for some reason, it doesn't want me to turn it over to her screen. So we'll try to let her do that. And so,
oh, there we go.
Perfect.
All right. Can everyone see my screen okay? Is it still connecting? All right. Is it connected?
Yes, we can see your screen.
Great. Well, first, I'd like to say thank you, everyone, for joining this call on keeping youth out of the adult court and the adult criminal justice system. As Allison mentioned, this is the primary mission of the Campaign for Youth Justice. And before we get started, I wanted to also give photo credit, the image that you see of the young person on on the screen is from the Performing Statistics Project in Virginia, and it was created by teens who are incarcerated in a local detention center there. I think it's always important to take a moment to remember why we do this work and why we fight for the young people that we do. So moving forward, I'm sorry, looks like it went forward a little too quickly. So I'd like to provide just an overview of what we'll talk about today. We are going to start, and I'm sorry, is anyone else seeing the piece on the side? I hope it's not interfering with the screen. I'm going to move that. So for just an overview, we'll start with some brief definitions just to make sure we're all on the same page in regards to some of the terminology for transfer. And then we'll move to the status of transfer mechanisms in the United States currently, which is in constant flux because of the legislative sessions. And then we'll move into some further discussion of opportunities for reform, and then also some litigation reform updates. And I will say we hope that this is the beginning of a conversation about how we can look at the intersections of legislative and litigation advocacy on transfer. And so we look forward to the question and answer period and for opening up that discussion. So just for a very brief overview of juvenile transfer, as I'm sure all of you know, since the creation of the juvenile court, states have always allowed for the transfer of some youth into the adult system, but it really punched up quite a bit in the 1990s when virtually every state expanded transfer mechanisms to make it easy for children to end up in the adult court. So what we know is that states have multiple mechanisms, which we'll go through shortly, and what we try to do is to figure out ways legislatively to block those pathways. So I will start with transfer mechanisms that allow youth to start in the juvenile court, even if they end up in the adult court. The first is discretionary waiver, also known as judicial waiver. It is the most common mechanism in the sense that most states have it. So 46 states, NDC, have this mechanism, and it allows a juvenile court judge to have full discretion over transfer of a youth to adult court. The second mechanism I have here is presumptive waiver, and that's essentially where a state statute specifies conditions appropriate to transfer a youth to adult court, but it permits juvenile defense counsel to argue for the youth to stay in the juvenile court, and 14 states and DC have that. Next, and the final mechanism in which you start in juvenile court that I'll talk about is mandatory waiver. So this is essentially once a juvenile court judge verifies very basic conditions like notice to the young person, they're a certain age, there's probable cause that they committed a certain offense, then at that point the youth must be transferred to the criminal court. The juvenile court judge no longer has discretion over whether or not that child, based on their individual circumstances, is a candidate for transfer. And so I wanted to highlight this mechanism. As you can see, I've listed the states. And the reason why, and you'll hear more about this during the litigation portion of the presentation, is that this mechanism is starting to be challenged through litigation. But at the same time, I will say that there are states that are expanding this mechanism when they're looking to do things like raise the age of juvenile court jurisdiction in their state. So that recently happened in North Carolina, where their raise the age law included expanding the mandatory waiver mechanism. So I think that's something to consider as we think about strategies moving forward to really try to challenge the placement of young people to the adult system. Next, I will go through the transfer mechanisms that start in criminal court. So first, there's statutory exclusion, also known as legislative waiver. So this is essentially when legislators set categories of qualifying offenses and ages that automatically exclude that young person from juvenile court jurisdiction. And many states have this, about 29, have this type of mechanism. The next is very similar in the sense that legislators decide this. It's the once an adult, always an adult provision or mechanism in which if a youth has a prior history in criminal court, that youth is automatically excluded from juvenile court in the future. Many states have that mechanism, 35 and DC. And then finally, there's prosecutorial discretion, and also known as direct file, and that is when a prosecutor can bring charges against a young person in criminal court. 12 states and DC have this mechanism. It is the mechanism where there's the fewest number of states that allow for this mechanism. However, it is definitely an area that we as advocates will need to pay close attention to, because the states that do have this mechanism, we notice that there is a lot of transfer through it, and so it's critical to really look at how that prosecutorial discretion is being wielded in the states where it is. Finally, I wanted to talk about reverse waiver. So reverse waiver is a mechanism that allows the criminal court to transfer a young person back to the juvenile court for adjudication or disposition. And 25 states have a reverse waiver. I wanted to highlight, though, that in 3 states, in Florida, Michigan, and Louisiana, and in the District of Columbia, so four jurisdictions have prosecutorial discretion, which means the prosecutor can put them in the court, but they don't have a reverse waiver mechanism. So the prosecutor truly has all the power in that situation, and I just wanted to flag that. The other thing that we're seeing in regards to the reverse waiver mechanism is that there's some legislation that allows reverse waiver to recur after a young person is found guilty. So in Indiana, there was a bill that basically provided that, if the young person was transferred up, but then they end up being found guilty of a sort of a lesser offense that wouldn't have resulted in them being transferred in the first place, they can go back down to the juvenile court and get a juvenile disposition. And so that's something we're starting to see in the reverse waiver legislation. So I wanted to talk more, go into more depth about each mechanism and what we're starting to see across the country. So for the status of discretionary waiver, so as I mentioned, discretionary waiver is when the judge can make those decisions. It's the most prevalent mechanism. But what we've noticed, looking at the data, and as you see in the next point, that according to the easy access to juvenile court statistics, the number of young people who have been judicially waived to the adult system has declined quite a bit over the last 20 plus years, as you can see in the data. It's gone down from 12,800 in 1994 to 4,200 in 2014. What I will point out, though, is that while we've seen a real decline in judicially waived young people, we've seen a pretty sharp increase in the percentage of Black youth who are being who make up that number of young people being transferred. So according to the Easy Access to Juvenile Court statistics, in 2014, we had the highest percentage of Black youth being judicially transferred than at any other time in which OJJDP was collecting data. And I think it goes back to something like like 1986 or so. So I think that's something to be really cognizant of. I also wanted to point out the 4 states, since they're rare, the 4 states that don't have the discretionary waiver mechanism: Massachusetts, Montana, New Mexico, and New York. And then finally, just wanted to make the point that while discretionary waiver is offered by the most number of states, again, what we're seeing is that it's actually through the other mechanisms, particularly statutory exclusion and direct file, that we're seeing more young people being pushed into the adult system. The other point I will mention, and this is for people to keep an eye on, is that there has been backlash against the discretionary waiver mechanism by system stakeholders. So we at the campaign recently saw a couple of pieces of legislation, only one of which passed, and which prosecutors basically said juvenile court judges shouldn't be allowed to make this decision for certain cases. And so they passed legislation that included additional offenses in which young people would be excluded from the juvenile court. So I just wanted to highlight that so that you're aware that if you start to see legislation in your state that seems like a little bit of backlash against there being some discretion to look at the individual factors of young people, that is something that we're starting to see and that we will need to push back on and to create messaging around so that people completely understand that it's important that young people are considered as individuals and that there's an opportunity for a trained judge to make that decision instead of it being automatic. So I'm going to move now into talking about the status of direct file reform. So as I mentioned before, there are a total of 13 jurisdictions, 12 states and the District of Columbia, that have prosecutorial discretion. So it's the least prevalent legislative transfer mechanism, and it results in a lot of kids being transferred. Recently, we saw 2 states end their prosecutorial discretion or direct file, Vermont and California, which is great. And we've also seen states really try to curb prosecutorial discretion, which is what Colorado did a couple years ago, I believe in 2012 or so. And what they noticed, I took some statistics from their report, was that cases for direct file dropped substantially as a result of them really limiting prosecutorial discretion by allowing for there to be more conversation around whether or not you should remain in juvenile court. So allowing for reverse waiver and other things to make sure that there's an opportunity to look at that child individually. So cases dropped from 144 in 2009 to 6 in 2015. I also wanted to mention some research on this particular point. So the research is called Assessing the Relative Effects of State Direct File Waiver Laws on Violent Juvenile Crime. And essentially what the driving point for me when I reviewed this piece of research was that they said, we feel confident in inferring from our results that direct file waiver laws have had little effect on violent juvenile crime. And I think they wanted to emphasize that while I think a lot of people say, well, if you have direct file, it'll be a deterrent, I think the idea is no, it doesn't work like that. And there's, I'm sorry, I think there is another slide. There we go. I think that the point was they're saying that it doesn't actually, again, just to say that direct file doesn't actually work to really deter. Oops, it's going backwards now. Let me see here. All right. So moving on to the status of statutory exclusion reform. So there are 29 states with statutory exclusion. Massachusetts, what we wanted to highlight in these points, or what I want to highlight, is that statutory exclusion, there are very different types of legislation out there. So you could have statutory exclusion like there is in Massachusetts, where youth are excluded when they're a certain age and only for 1 or 2 offenses. In the case of Massachusetts, it's first or second degree murder. Or you could have the situation like it is in Maryland, where you have statutory exclusion for youth between the ages of 14 to 17, but there are 33 offenses that can result in that young person being excluded from juvenile court. And I pulled out a piece of data from the Just Kids campaign website where they highlighted that it's ineffective, because at the end of the day, almost 60% of youth in Maryland who are statutorily excluded eventually have their cases dismissed or moved to juvenile court. So essentially, statutory exclusion there has created this real waste of placing a lot of kids up and then having to move them back down, which is a waste of time, it's a waste of resources, and of course it gives a child a record that they don't need to have, and so that's something that Just Kids and their campaign highlighted as they continue to push against statutory exclusion. I wanted to talk briefly about some legislative victories related to statutory exclusion and limiting statutory exclusion specifically. So in Illinois, there was a bill in 2015 which removes armed robbery with a firearm and aggravated vehicular hijacking with a firearm from the list of offenses that are automatically statutorily excluded from juvenile court. And similarly, in Utah, there was a bill that really tried to limit the exclusions by basically saying that instead of it being, every felony, they created some boundaries around the types of felony offenses that have to be that are statutorily excluded from juvenile court. We also have some research related to statutory exclusion that's come out over the past couple of years. So this particular piece, Legislative Waiver Reconsidered, General Deterrent Effects of Statutory Exclusion, and essentially what they found was, again, similar to with direct file, that there generally was not a deterrent effect. And so I think these are the pieces of research that we want to highlight when we're making arguments to legislators and to others to say, I understand that one of the reasons why you set this up is you believe that it will have some type of public safety deterrent effect, but there's been lots of research to show that it has not. And there's actually been very recent research on statutory exclusion. This piece called Do Criminal Court Outcomes Vary by Juvenile Transfer Mechanism. And when you dig into this particular article, what he really highlights at the end of the day is, again, that statutory exclusion, or legislative waiver, as he calls it, is a really ineffective and inefficient mechanism. And in fact might be a harmful one. And it's because of the reasons highlighted by the Maryland example, right? You have so many young people ending up in adult court who end up being weighed back down because they don't need to be there. And so the takeaway from that article was that youth who were transferred through this mechanism, they were actually less likely to be convicted. They were less likely to be pushed farther into the system. So you can make the argument that, well, you're wasting resources by using this mechanism. You need to use a mechanism that is more proven to actually end in, that young person going through the process, because so that was the takeaway of that particular article. Some other transfer legislative victories that I wanted to highlight was that there's been a growing number of states that are looking at what I call raising the floor, which is essentially when it's a legislative effort to limit transfer by raising the lower age at which a young person can be transferred so that younger youth are not eligible for transfer. So we've seen this happen in several states. We've seen several states also try to push this. I know in Missouri this year there was an effort to raise the transfer age there from 12 to 16. And so I think that this is an interesting area to also keep your eyes on. So related to that, I wanted to give more details on the legislative opportunities when you talk about raising the floor or raising the lower age of transfer. So when you look at what the minimum age is for states that have judicial waiver, it's pretty young, right? So there's some states where they don't list the minimum age, but generally most states set it around 14. But I think that you can make the argument, especially if you're in a state where there is no minimum transfer age, if you're in one of those states or in one of the states where it's at 10 or 12 or 13, you can make the argument that, you know, it's out of line, right? Because most states are really moving that age up and try to really push for that so that you're limiting the ability for transfer, especially of the younger youth. Similarly, this is a slide just showing the need to raise the floor for statutory exclusion. So what we've generally seen is that most states, when they say statutorily exclude a young person for a certain offense, they set the bar a bit higher. But there still, of course, is room for saying, you know, if you're going to automatically exclude, you need to set it higher. So I've listed the states here in which they set the statutory exclusion age a bit lower, because again, that's something you can argue for pushing up based on looking at sort of the traditional age that's used in other states for statutory exclusion. And I think another opportunity that I will highlight that was pointed out to me was that there are some states where there's not a minimum age for a judicial waiver, but there is a minimum age for statutory exclusion. So I believe Rhode Island is an example of this. And it's important to highlight that because maybe that could also be used there to say, hey, you need to set a minimum age for all of your mechanisms. Like it shouldn't, you know, to make sure that you're protecting all young people. So I have just a quick overview of some opportunities for legislative reform based on what we have seen across the country. So the first, as I just was going over, raising the age of statutory exclusion, judicial waiver, and direct file to adult court, so that you limit the number of youth who are at risk of being transferred. The second is limiting the offenses that are statutorily excluded or direct file eligible. So trying to really chip away at the long list if you have a particularly long list in your state. The third is challenging direct file and prosecutorial discretion. As I mentioned earlier, Vermont challenged direct file through legislation. California challenged it through a proposition. So they had different strategies, but both were successful in saying we don't need to give all the power to the prosecutors. There actually needs to be more individual consideration given to each young person. The fourth is adding or strengthening reverse waiver mechanisms that allow for removal of youth back to the juvenile court, whether it's before or after adjudication. So really focusing on you know, if your state is very resident, are really, you know, they're going to keep their mechanisms and will actually likely try to expand them. One thing you can push for is at least having a reverse waiver mechanism or expanding or strengthening it. The fifth is requiring judicial training on the impact of transfer. It's incredibly important that both our juvenile court judges and our circuit court, our adult court judges, are aware of the long-term impacts of transfer for young people. Especially there's been some research recently out this year, I believe by the Academy of Pediatrics, about the long-term health impact of young people who are incarcerated, and of course the suicide rate, the rate of sexual and physical abuse for youth who end up in adult facilities. So it's definitely important to provide that. The next opportunity is training for juvenile defenders to make sure that they can represent in waiver, transfer, or amenability hearings so they can effectively advocate for their clients. And then seventh, require data tracking of transfer based on race, charge, plea. This is something that we're starting to see more states try to do, and it's incredibly important, because that data will be how you can make the argument to push for further reforms. And to be absolutely honest, there's not enough data out there about what is happening, especially when you look at mechanisms other than discretionary waiver. So to really track, direct file numbers or youth who are statutorily excluded, that is really, really important. And then finally, adding more individualized factors that must be considered in a waiver or transfer hearing. So making sure that there are some specific things that must be considered by a juvenile court judge to help make sure that every youth has an opportunity to have certain factors considered to move forward. So with that, I will hand it over for a discussion related to litigation and transfer.
Great, thanks, Jerry. We just wanted to conclude the discussion with a quick overview of the trends that we've been seeing from the courts on the validity of these various types of transfer statutes and information or decisions from the courts about how transfer is carried out in practice. So at the Juvenile Law Center, we approach litigation generally in the juvenile justice space, but also in the specific area of transfer in the adult system through the framework of youth development that has been established from the Supreme Court. In their long line of cases, Roper v. Simmons, Graham v. Florida, Miller v. Alabama, that really highlight two important themes. First, that children are different from adults. They're less mature, they're more susceptible to peer pressure, they're much more amenable to rehabilitation and have the ability to change. And second, that children are different from one another. So in putting children in the juvenile justice system, it's very important in the various stages to give them individual consideration, whether it's during sentencing or during transfer, to recognize the fact that children are different from each other. And in cases like Kent v. United States, which talked about transfer, and Miller v. Alabama, a sentencing case, the Supreme Court identifies relevant factors that should go into these inquiries of whether children should be transferred or what type of sentence they should receive, the types of factors that should be identified. And using this framework in litigation is important and it's very helpful because it demonstrates why transfer to the adult system is problematic, how it subjects kids to the harshest punishments, even though they have the capability to change, and they're just not as culpable as adults, and why, robust due process procedures are necessary in order to ensure these individual factors and differences between children are appropriately considered. So currently, the Juvenile Law Center's work and the work in this area in litigation, one focus of it has been the mandatory transfer statutes that we've discussed earlier in this webinar. And these are the statutes that, once again, provide for very little or no judicial review of transfer decisions, and as long as somehow kids commit a certain crime or are indicted for something, or there's probable cause that they did something and they are of a certain age, they're automatically transferred to the adult system, and there's no judicial review of that decision. And unfortunately, there has not recently been a case where the courts have held that these mandatory transfer statutes are unconstitutional. And there was a very brief victory in Ohio with State v. Allen, but that case was reconsidered by the Ohio Supreme Court, and just last month in May 2017, the decision was reversed. And at issue in this case is the under the Ohio statute, transfer occurs automatically if there's probable cause to believe that the youth was 16 or 17 and committed certain offenses. So in the original Allen decision, the Ohio Supreme Court found that the mandatory transfer was unconstitutional, and this violated the juvenile's right to due process as required by the Ohio Constitution, because there was, besides the initial determination of probable cause, there was no specific hearing that determined that the child couldn't be rehabilitated or for some reason needed to be in the adult system instead of the juvenile system. And this violated the juvenile's right to due process. Unfortunately, the state, after this decision came out, filed a motion for reconsideration, which the Supreme Court granted, the Supreme Court of Ohio, and they vacated their decision. And in this new decision, the court essentially just held that the proceedings that determine probable cause are sufficient process, so there doesn't need to be a separate hearing on the transfer itself. And there was also an equal protection argument made that the court also did not accept. And essentially the court says that because prosecuting older juveniles who commit serious crimes in adult court is rationally related to a legitimate state interest of fighting rising juvenile crime, and therefore it's okay if there is a difference between how various youth are treated in the juvenile justice system because it is related to this state interest. So it is important to note in this decision that there are political implications that make an impact on litigation as well. And so the only difference, which is something that was pointed out in the dissent of the second Allen, the reconsideration, is that the only difference between the first case, the first Allen decision, and the second Allen decision is that there were 2 new justices added to the Ohio Supreme Court, and these are justices that are elected, and so there is a political implication or there are political reasonings for the difference in the 2 decisions that didn't have anything to do with other facts. But regardless of that setback, we are moving on to other cases that make similar types of arguments regarding mandatory transfer statutes. So one case that we very recently worked on was in Louisiana. And in Louisiana v. Clark, there's a very similar type of mandatory transfer statute at play, which essentially requires that once 15-year-olds or older have been indicted of certain crimes, they are automatically prosecuted in the adult system or they're automatically transferred to the adult system, also with no judicial discretion. And so in the briefing for that case, we argued that there's similar due process concerns in that there's no consideration of the factors identified by the Supreme Court in their Kent decision, and there's no sufficient hearing that the individualized differences of children to be discussed or the individual circumstances of a child to be discussed. As long as they're indicted of a crime, of a certain crime, that they are automatically put in the adult system, and this is not appropriate review. And then second, we've made a similar equal protection argument regarding the fact that some children, 14-year-olds, get meaningful review before being transferred to the adult justice system, while other children, 15-year-olds, don't. So, there could be good decisions coming out of Louisiana on that point. In cases that have been more successful, there's been a few themes that have emerged, and one of these is based on like a focus more on sentencing than the transfer procedure itself. And so even when a transfer statute has not been found unconstitutional, the impact of transfer to the adult court has been mitigated. And one area we've seen this is in the state of Washington with the Washington v. Houston Sconiers case, which also just came out in 2016. And Washington had an automatic transfer statute as well that we argued was unconstitutional because of due process concerns, but the court declined to address the validity of that statute, but did drop a footnote that said they didn't foreclose the consideration of a due process argument in the future. They just didn't want to do it in that particular case. But regardless of the not addressing the transfer issue specifically, the court did really take into consideration the Supreme Court's explanations of how children are different under the Eighth Amendment. So even if youth are being prosecuted in the adult justice system and there are, mandatory minimums or other statutory sentencing requirements, those don't have to be taken into account, and judges have absolute discretion to depart from them when sentencing juveniles in the adult court. So even if they are still being prosecuted and sentenced in the adult court, at least one harm of the adult court, which is these very, very long sentences that juveniles get, is mitigated through this decision. And finally, the last theme comes from a couple of cases out of Texas, which is really one thing we've seen in transfer is the courts emphasizing the importance of individual consideration in the same way that it's been considered very important by the Supreme Court in their sentencing cases. One case that particularly highlights this is Moon v. State of Texas. And Moon had a different transfer statute at play than the ones we've been discussing, in that their transfer statute gave judges discretion in waiving jurisdiction, and it provides some statutory factors of what judges should look at. But what was happening in practice is that the juvenile court judges were essentially rubber stamping transfers without providing real analysis or real explanation of why they felt a juvenile should be transferred. And so in Moon v. State of Texas, the court explained that that was no longer sufficient, and juvenile court judges must show their work and provide evidence on the record on why a juvenile is transferred, and this allows the judges to really provide information about why they're doing their transferring, what factors led them to that conclusion, and it allows appeals courts to better review that decision. So that's a good win for youth in Texas, and we recently filed an amicus in another case, Ex parte Navarro, which is urging the court to apply Moon retroactively. So not only will future juveniles get the benefit of the decision, but there also would be a review of other individuals who have been transferred in Texas as well. So overall, there has been successes in keeping kids out of the adult system, or at least mitigating the damages of the adult system by challenging sentences, but litigation still really remains a challenge. And there's a couple of reasons for this, partly because when you're dealing with transfer statutes, courts do give a lot of deference to the decisions of the legislature, especially when there are public safety reasons that the government can articulate of why they need various transfer statutes. There's also, as Jerry was discussing, there's like a lot of data that's required, so we can accurately show that there's disparate impact of these practices on youth of color or other communities. But because of this challenge, it's really important for litigation and policy change to kind of work on both of those things together in order to really be successful. And as legislation is passed around the country to deal with better transfer statutes or getting rid of transfer statutes,
or giving judges more discretion, this supports successful litigation as well.
Thank you, Nadia. Do folks have questions? I know there's a lot of echoing. Sorry, that was all probably me. We're happy to take questions, and if folks can raise their hand either in the control panel or if they want to type in their question, I can field them and relay them to our presenters. Looks like Janice Evans has a question, so I will I recognized your hand, and I think I'm unmuting you. For some reason, it doesn't want me to do that. Oh, you're self-muted. So if you can unmute yourself, Janice, you can answer the question or ask your question. Are you there?
Yeah. Can you hear me?
Yes.
Okay. I'm in Oregon, and I'm just wondering about the Measure 11. Is Oregon the only state that has that Measure 11, where it applies to juveniles as well as adults, or is there any other states that carry Measure 11?
So it's called different things, but unfortunately, yes, every state has a mechanism in which a young person can be transferred. So it's called different things and looks different, right, depending on what state you're in. But unfortunately, yes.
Okay, so that would be the mechanism of Oregon, is the Measure 11.
Right. So while that's what it was called in Oregon, that's how it got passed and everything. It's similar to what other states have, but it just might have been passed through a different mechanism.
Yeah. Okay. Yeah. I'm just unbelievable.
Yes, absolutely. I will say, though, that Oregon recently passed legislation, actually passed this year, to actually keep youth under 18 out of the adult prison system in Oregon. And so there at least has been some movement there, but of course that's not enough. So you're absolutely right that the next challenge is really figuring out how to chip away at Measure 11.
Yeah, we still have juveniles in shackles and chains and gigantic padlocks. I mean, here's a 89-pound child with these like pit bull dog chains on him, and he can barely walk. It's heartbreaking. You know what I mean? It's heartbreaking. Yeah. But we're passing that too, I believe, because that's up right now. Okay, well, that was it. That was my question. I just wondered. I didn't realize that all the states have it. They just kind of word it different. Oregon also says they don't call it solitary confinement in a juvenile facility. They call it in and out, which I think is just like a blanket coverage for solitary confinement, because they'll correct you and say, no, it's not solitary confinement, it's in and out. And I mean, it's just frustrating. It's like a dog chasing your tail, trying to get these kids to be looked at differently. You know what I mean?
Yeah, absolutely.
Yeah. Okay, well, thank you.
Yeah, thank you for your question.
Okay, and I'm so glad to attend this.
Wonderful.
And it looks like we got about 5 more questions in, so I was going to try to run through them. I'll read them for folks just to try to get through them in time. So a question from Rachel Gassert in Louisiana was, do you have messaging guidance for legislative change, particularly to combat pushback about rolling back prosecutorial discretion?
So that is something that I know that the campaign, along with a couple of organizations that are looking at how do you talk about particularly serious offenses, right? And so while we don't currently have it packaged now, that is something that we're absolutely working on with a couple of other organizations that are looking at how do we message, particularly around serious offenses.
Thank you. And then George in Washington asked, any other state other than California tried to get rid of auto transfers through a referendum or initiative process?
Oh, sorry. I'm sorry, can you repeat that?
Of course. He was asking if any other state besides California has tried to get rid of automatic transfer through a referendum or initiative process.
I am not aware of that, but that's definitely something I can look into. Allison, I don't know if you've seen that in your work either, but I believe for right now it's California, although as was just mentioned, if Measure 11 could get challenged, that would be one way to get rid of the statutory exclusion there. So unfortunately not yet, but hopefully that is a method that gets used, and we can use that model to move forward.
Yeah, I agree with you, Duri, that California is the only one I know of who's used the referendum process. But there are a handful of states working on auto transfer, which will hopefully make headway. So the next question is, how do you envision an ideal balance of discretionary waiver, since you mentioned raising the age as well as giving more discretion?
So, well, I always have to start by saying, of course, in an ideal world, there would be no question that youth remain in the juvenile system, right? And so that would be the ideal. But what we, of course, see in states is that they want to have some kind of mechanism to move kids to the adult system. So I think when you do have discretionary waiver, I think the most important thing is to try to perhaps do legislation that mimics what we saw in the litigation in the Moon case, right? So require that there are factors that judges must consider, and that there is reasoning behind it, and that there's data collection, right? Like figure out how you can really create accountability measures. I think that's what I would say to that.
Thank you. And then Lawrence in Maryland mentioned that he's a social worker who, sorry, I just lost it, but for waiver and transfer cases. So he was asking whether it would be of value to include more of the literature into his reports, and asked what studies you think are most powerful to impact judges' opinions on transfer.
So we highlighted a couple of studies. I think that, and I'm happy to figure out ways that we can make sure people have the names and can identify that research. I think it's tricky because for individual cases, the most important thing is highlighting the individual needs of that kid. But some of the research that I did highlight in the presentation, I think particularly the recent, I'll try to see if I can go back in the presentation, the recent research related to the fact that direct file and statutory exclusion are not effective means, and that in Maryland, as I mentioned, a lot of kids end up just going back to the juvenile court, right? Like really highlighting maybe some of those pieces, I think would be helpful. So that kind of, I think we'll probably be able to share this PowerPoint, but maybe reviewing that in particular, that piece of research in particular, would be helpful. The Campaign for Youth Justice also, we keep a list of research on our website, and we are revamping it to try to add as much as we can. So if you have the opportunity to go and do some searching, we plan on having it by sort of different topics and by state reports and federal reports, and that could be a good resource to include in those reports as well. And
the next question is from Lori Waller, who asked, or mentioned that judges tend to transfer juvenile sex offense cases, and asked if there's a way to get judges to see beyond the sex offense and see the kids as individuals. So I don't know if anyone can speak to that.
So it's interesting. I will say that that's, so it is tough, extremely tough. There is a lot of research out there specifically related to juvenile sex offender cases and their recidivism rates. And actually one of the documents that I used in this presentation was specifically about that that issue, and so I'm happy to include that in any further sort of communications that we send out. But the source is on the presentation. I believe it was through the SMART office, like it was through a federal Department of Justice office that put out a report on specifically on juveniles and sex offenses. So I mean, one thing you could do is really, you know, an attorney can try to make the argument around that. Of course, again, individual factors are important, but there is a lot more research on the fact that there are lower recidivism rates, and if there are community-based treatment options for those youth, those have proven to be more effective.
And then the next question is, what kind of opposition has arisen around efforts to create a reverse waiver?
Well, I from what I can gather, I don't know for every locality, but from what I can gather, there's always public safety concerns about certain offenses, right? Whether it is, you know, it is a quote-unquote violent offense or it's an offense that involves a gun. Usually that is where you'll hear pushback regarding creating reverse waiver, but that's what I have generally seen. That has been the pushback when there is pushback.
And then 2 more questions, so we'll try to get through them really briefly, so bear with us, everyone. But do states have proposed legislation to address transfer in 2018?
So I hope so. So in a lot of places, their 2017 legislative session has just ended or is coming to an end, and so there's not yet in many places specific legislation on this, because it'll sort of come out towards the end of this year and the beginning of next year. But I absolutely hope so, and I think that there will be, because there are great state advocates across the country who are focused on this work and that we support, and so I absolutely believe that there will be some efforts on that. I think that the one thing I will say is that we need to be very vigilant again about there being backlash to legislation, because we did see that this year. I think it was one of the first times that we really saw that and over the last couple years. So that's a little bit concerning, because I think generally the message has been getting to people that that kids are different, as Nadia mentioned. Like, that message has been getting to many legislators, but there is always a concern of people of there being some backsliding, and so we want to look out for that. And something else I'll mention, to go back to an earlier question, was that there is some polling on messaging. I forgot to mention that, but there is some good polling. But of course, that's usually very specific to your state, so you'll want to get good state polling on that and see if that's helpful in how you message around the transfer of young people. The only other thing that I want to just make a quick plug is to say that the campaign is working with pro bono partners at Skadden Arps to hopefully do a really comprehensive review of transfer litigation and legislation that we hope to be able to share with the field soon. Thank you.
And Sheila Turner, I did not miss your question. I saw that you asked about whether the slides will be available, and so I just want to mention to everybody who's on the line that we'll share the PowerPoint as well as the recording from today's webinar with everybody. And it'll include the contact information for both Jeree and Nadia if folks want to follow up with them. So you guys should feel free to ask any questions that I might have missed from today's webinar to us all. So thank you for bearing with us. I know it's 2 after 4. So thank you so much, Jeree and Nadia, for sharing this information with the field. We'll be sure to get your information and share it with folks as well as this information. And we just really want to thank you for your time and for sharing your wisdom with us all.
Thank you.
Thank you. Thank you.
Have a good afternoon, everyone, and we'll share this shortly.